Hi everyone, welcome to PyData. Thanks for coming out on this icy evening, risking your lives. My name is Patricia Schuster, and I'm a postdoctoral fellow at the University of Michigan. Sean Law is also here, who works here at TD Ameritrade. And our other co-organizer, Ben, is not here tonight. We want to start by acknowledging our sponsors for PyData for our Meetup group. NumFocus sponsors the Meetup group itself. TD Ameritrade provides us this space to meet in, and Midas provides the food. So if you know anyone from any of these organizations, next time you see them, say thank you. A few notes, especially since we have so many new participants today. We have emergency exits here through this door. If you have any feedback about the event, please provide it to us through a few different ways. Either Twitter and Gmail is here at the bottom, PyData and Arbor. We do put a lot of content from our meetups on our GitHub, and the link is right here. And as a reminder, we're in a borrowed space, so please clean up after yourself. So as for Q&A with the presentation, unless your questions are quick, please hold questions until the end. And try to phrase your questions in the form of a question. And keep your questions to 30 seconds or less. And avoid going into long statements. So we will have time for open discussion at the end. Now I want to read our code of conduct. PyData is dedicated to providing a harassment-free meeting experience for everyone, regardless of gender, sexual orientation, gender identity and expression, disability, physical appearance, body size, race, or religion. We do not tolerate harassment of meeting participants in any form. All communication should be appropriate for a professional audience, including people of many different backgrounds. Sexual language and imagery is not appropriate for any of our meetup events. Be kind to others, do not insult or put down other attendees, behave professionally. Remember that harassment and sexist, racist, or exclusionary jokes are not appropriate for PyData. Attendees violating these rules may be asked to leave the meetup at the sole discretion of the meetup organizers. Thank you all for helping make this a welcoming and friendly event. Now we want to do a quick icebreaker so you can meet some of the other people here. So please turn to somebody you don't know and introduce yourself. And then in 15 seconds, please reflect on the title of the talk today, Privacy is Not Dead, and tell them whether you agree with that statement. We're going to let you.
Well, I was like, I won't fit you guys talk to me since I'm giving the talk.
Hi, I'm Doa.
Hi, nice to meet you. Ashley. Hi, Helen. Nice to meet you both. And you guys are my lawyers, right?
Yeah, yes. We're at Butzel just down the street.
Okay. And do you practice in this area?
Yes, okay. We're starting out.
Okay. Good. Yeah, it's a lot. It's complex.
Especially all the changes happening. Changes proposed to be happening.
Right. This is going to be very, because I was expecting more of a scientist background, right? Not deterministic English. So it's going to be very, also a data scientist. Thinking just using some, it's almost, the second half will be almost like a law school exam kind of question, right? Thinking through the issues and how they apply. So maybe a little different from a normal law event, go to. But so what do you think though to her questions? The name of the
I think I'm dead, but it might be yours.
Yeah.
It's definitely alive and well in Europe.
Right.
I think it's dying. I think. Process of dying.
Okay.
I was just we were at a conference last week, and one of those workshops that I went to was on data privacy, and kind of covered this same sort of topic where we talk about how more and more, for the sake of convenience, we're giving up our privacy. So I think it's dying. I don't think it's going to be dead forever.
Right.
We're giving up more and more information for the sake of convenience.
Yeah, for sure. Yeah.
Let's start up again. Can I get a show of hands? Who says privacy is dead? Who said it's not? All right, we're split just right around the middle. Right down the middle. So it should be a great talk then. So we want to mention a few things of data science. This month in data science, there's an AI company called DeepMind that participated in a protein folding competition, and they built a model called AlphaFold And it actually beat out the prominent scientists in the field at predicting protein folding. So this is a big application of AI to an academic field. Pretty interesting, especially for us academics. I also want to promote the next event next month, Medican Monk. She is very famous in the nuclear engineering world, and her talk will be on widgets, Jupyter widgets for volumetric data explorations. She's from the University of Illinois. So that'll be March 13th. Also want to mention an event coming up from our friends at A2 Deep Learn. They are hosting their event later in the month, and it's free, but you need to sign up in advance, and it's hosted with the University of Michigan, so it's on North Campus. Are there any community announcements? So now's your time to share any things that you want to share with the group, maybe if you have a job opening or if you're looking for a job. Hand in the back.
Yeah, I'm looking for work, software developer, mostly with critical infrastructure work, Python, C, C++.
And your name?
Keen.
Keen, yes. Okay, so if you're looking for people, talk to Keen.
I'm working on a data analysis project with healthcare data for a volunteer project, and I'm looking for anybody in terms of legal expertise on how to handle identifiable and non-identifiable healthcare data.
Great, and your name?
Sam.
Sam.
Recent translating.
We know someone who can help.
Excellent. And did I see one more hand? Brian?
I'm Brian. I work at Interactions. We're sponsoring the TD Learn. We have an open rec for our data science team. So it's a lot of Python, deep learning, NLP focused. So people have experience with that.
Excellent.
Was there one more?
One more, Anusha?
Yeah, so I'm actually looking for a job. I'm a master's student at machine learning and data science, but I'm an entry level. This is going to be my first job, so just in case, and I'm open to relocation.
Excellent. All right. All right, so now we will start the talk. Our speaker today is Helen Odom. She works here at TDA as Senior Legal Counsel, where she helps the business work through complex legal issues at the intersection of technology, media, brand, and innovation. And her talk will be called Privacy is Not Dead. So let's welcome our speaker.
Well, thank you for having me today. Sounds like this is going to be a slightly different topic from what you're used to hearing about. I didn't even know what those words meant for next month's speaker, so that sounds pretty cool. Right. Excellent. So the topic today is privacy isn't dead, and I guess it's kind of intentionally, unintentionally provocative, right? I wanted to make sure, got some people's attention. Rarely does privacy law get people really excited, but hopefully this at least gets your attention. And I wanted to talk about this because I do think, as we saw from a show of hands earlier, right, there is this idea out there that people don't care about privacy, that it doesn't matter, that it's dead or it's dying. And I believe, for one, that that's not true. And that probably privacy matters more today than it ever has in the history of humanity, and especially privacy as a legal right and a legal concept. And that's what we're going to talk about today. And especially when you look at the activities of lawmakers and of regulators, and even this, one of many similar statistics that the vast majority of at least US consumers are in favor of passing a national data privacy law, right? So this shows that people actually do care. They're concerned about how their data is being used, what's happening with it, and they want some more controls in place. What are we going to talk about? So the intersection of data and the law is a really big topic. We're going to be covering what is privacy exactly, what do we mean by that. We're going to cover the history of privacy and kind of the evolution, very high level history of it, the evolution of privacy laws. And then we're going to apply the principles that we learn about to the Internet of Things more specifically. So we'll have a kind of fun little law school exam moment for us at the back half. We're not going to be covering data breach. We're not going to be covering data security. We're not going to be covering international privacy laws in any real depth. And I'm not going to be talking about company or industrial data. As the name suggests, privacy really talks about personal information, personal data. Although with Internet of Things, there's actually a really kind of interesting convergence now between personal information and industrial data, which we'll talk about a little bit towards the end. Okay, so let's start. What is privacy? Well, I think a lot of people think that privacy has to do with solitude and seclusion. The idea of kind of the hermit going off in the woods alone. You know, one reason for this beautiful image here. But that's not exactly right? Because solitude is actually about not being around other people. You're physically not present with other people. But you can be present with other people and still be private, still have privacy. Another idea about privacy is that it has to do with secrecy, right, or hiding information. And we kind of get this sense that only bad people need privacy, right? Only criminals or people who have something to hide actually need or want privacy. But that's also very much not true, right? I mean, if somebody were to out you as gay or as pregnant, we would have a problem with that. That's not okay. And I think especially that idea that privacy is about secrecy can potentially become very dangerous when it's used to justify invasions of privacy, such as we see with mass surveillance programs. Right? It's a very slippery slope when you start thinking that way. So if it's not about solitude and it's not about secrecy, what is it? Privacy, the legal sense of privacy, is the control that we have over information about ourselves. Okay, so it's the right to control information that we have about ourselves. And the reason why privacy exists as a right, or why it has been identified as a right, we're going to go into that in a little bit, but privacy really gets to fundamental aspects of our humanity, right? It gets to our ability to identify ourselves, to control our identity, self-determination, to determine who we enter into relationships with. So privacy is really it's one of those things that's at the root of just our very human nature. And that's one of the reasons why it's actually been recognized in the Universal Declaration of Human Rights as a fundamental human right, because it is so essential to our humanity. And I thought I turned off Slack, but apparently it still works. Sorry about that. So let's start with the history of privacy then. Where did this idea come from? Because it's actually somewhat of a modern legal concept. Most legal scholars trace the history of privacy back to a law review article that was published in the Harvard Law Review in 1890. And it was called The Right to Privacy. Aptly named. And the history of this article is kind of the stuff of legal legend. It was the late 19th century, and it was the era of yellow journalism. And Samuel Warren, one of the co-authors, his family was part of Boston's social elite. He had married the daughter of a senator. And their personal lives were just covered in excruciating and embarrassing detail by the press at the time, just hounded by the paparazzi, basically. And I guess there was an incident at his daughter's wedding, and it just kind of put him over the edge. And he turned to his law partner and law school classmate, Louis Brandeis, who, lucky for him, went on to become Supreme Court Justice, so a kind of brilliant legal mind. And they put their heads together, and they basically invented this right to privacy. They wrote this article where they made the argument that this right existed. And what they did was they went back and they surveyed hundreds of cases, all the way back to English common law. And they looked for cases that had issues that were kind of similar to what the Warren family was experiencing. And they looked at how those cases were being decided and saw that they were being decided on just all sorts of legal grounds: property, contract, intellectual property, defamation, different torts. So just really all over the map. But what they identified was that what was really going on was the courts were actually recognizing that there is a different legal right here that is not addressed by these other regimes, by these other doctrines. And that other right was, or that other issue was the unconsented publication of true facts. So, you know, in a defamation case, for example, if someone were to publish something about me that's not true, that would be a claim for defamation because it's not true. But if you publish something about me that's true, for example, maybe I'm gay or I'm pregnant or whatever, that's not defamation because it's true. But there still is a wrong there, right, that needs to be addressed. And so they identified basically this unmet need in the legal doctrine at the time and said, that's really what the courts are doing here. And they termed that the right to privacy. And they said the time has come basically that this right should be acknowledged for what it is, and it should be given teeth, and, you know, it should be enforceable. And that's, you know, that's how this whole idea of the right to privacy got started. They define the right to privacy in the article as the right of determining to what extent one's thoughts, sentiments, and emotions shall be communicated to others. So again, it's that the idea is that it's the right to choose and to control the information about yourself. Now, in the 100 or so years after the publication of this article, we've seen obviously a very dramatic evolution of this right to privacy. I would say the first few decades, there was not even a lot of agreement about whether they got it right and whether this right actually did exist or if it should exist. The court slowly started catching on and kind of experimenting and issuing cases that were decided under this right to privacy, but wildly inconsistent decisions, just all over the map. No agreement about what this right actually was or how it should be applied in a legal context. And actually, William Prosser, who authored the Restatement of Torts in 1860, identified that by that time there were at least 4 separate different tort claims that were all being asserted, all under the name right to privacy, but they were actually completely different issues and completely different wrongs. So there's just a lot of confusion at the time. What is this right and how should it be applied? But also at that time, you see a lot of development in technology. And by the 1970s, the government is now at this point using computers and computer databases to process records about citizens. And this was starting to raise a whole host of concerns from the public about, about their privacy and about potential abuses. And in response to those concerns, the Secretary of Education put together the Special Advisory Committee to look into these issues with the use of automated data processing systems to process the records of citizens. In particular, they were looking at like Social Security numbers and what was happening with Social Security numbers at the time. And they were supposed to come up with some recommendations and guidelines to protect civil liberties. And they did that, and the result was this report published in 1973 called Records, Computers, and the Rights of Citizens. And the guidelines that they put forth was this Code of Fair Information Practice. And it's these 5 simple principles that eventually became codified into law. The following year, the Privacy Act was issued, which still is in place today and governs all federal agencies and how they process data. So this report's still very relevant. The Code of Fair Information Practice eventually evolved into something a little more general framework that we now call the Fair Information Practice Principles. And these principles are articulated slightly differently, kind of depending on where you look, but it all kind of boils down to these 5 basic principles. And this particular articulation I pulled from the Federal Trade Commission Act, the Federal Trade Commission's report to Congress in 1998 on online privacy. But the principles are as follows. The first is notice and awareness. And this is, as the name suggests, the idea that consumers should be made aware of how their information is being collected and used before it's actually collected and used. The second and closely related principle is choice and consent. And this is the idea that consumers should have an option about how their data is going to be used, in particular secondary uses. The third principle is access or participation. And this is the idea that consumers should be able to access what information companies have about them. And this is going to be really familiar to us, for example, with the credit reports, right? Everybody gets to get one free credit report from each of the credit reporting agencies every year. And that's because of this principle. The fourth principle is integrity and security, and this gets to the idea that the information we have about consumers should be accurate, right? It would be bad if somebody said, I'm an 85-year-old male and I'm actually, a woman in my 30s. That would be inaccurate and bad. And it should be secure, which means obviously that it should be secured from unauthorized disclosure. The last principle is enforcement or redress, which simply means that these principles have to have teeth, right? People have to be able to enforce them. There has to be some kind of a stick that's going to get companies to comply with these principles. And the FIPS essentially form the basis for every single privacy law around the world today. This notice and choice model that they, that they propose is basically the model around the world. And this is just a snapshot of privacy laws now. I will say, I pulled this in December. It's a little bit out of date because Brazil in 2018 passed their first data privacy law. It doesn't go into effect until next year, though, which is probably why it's not up on the map. But you can see that, data privacy laws are just, they're proliferating around the world. And 2018 was actually a particularly active year, I would say, for privacy legislation. It was the year that the General Data Protection Regulation in Europe went into effect, which was the just huge overhaul of their data protection directive, the first in decades. Extremely onerous compliance conditions, extremely harsh penalties if you get it wrong, right? Up to 4% of your global annual turnover if you get it wrong. So that's a big deal if you're, a Google or a Facebook. Also, in the United States, 2018 was a big year. The most notable update of 2018 for the US was the passage of the California Consumer Privacy Act, which is considered the first GDPR-like legislation in the United States. California has always been kind of at the forefront of privacy legislation. They were the first state to pass a law that actually required a privacy policy being posted online, and they just have always kind of been on the cutting edge of privacy issues. But they passed in record time, I think 2 days, this legislation in order to avoid it becoming a constitutional ballot initiative. So because it was passed so quickly, there are actually a number of errors and ambiguities and inconsistencies that they're trying to figure out and correct before it goes into effect next year. But you see here, I just have a snapshot from the preamble of this law, the intention of the California legislature, right, and what they're trying to do with this new big omnibus privacy law. And the principles here basically are, again, the FIPS in action, right? It's these same principles that they're trying to protect. We're going to talk more about the CCPA in our hypothetical in a bit, but I will just, again, echo that it is very broad. And even though it's a California law, it will apply to any company that collects personal information from 50,000 or more people, households, or devices that are in California. So, yes, sir?
You had mentioned that there was a codification where the federal agencies were bound by fair information practices.
Mm-hmm.
Does that ostensibly apply to the NSA? Are they bound by it?
Ostensibly, but there are other laws that come into play with the NSA, and I mean that's just the first of many. This is not by any account a survey of every single privacy law in the United States. That would take years to go through that in detail. Right.
Where they can get out of it.
Right. No, understood. Yeah. So back to California, though. Thank you for the question. Again, this law is intended to be broad and have broad application, just like the GDPR. And collection under this law is both active and passive. So that would apply to, for example, cookies, collecting IP addresses through cookies. Now is specifically covered under the CCPA. A little bit of ambiguity before if that was actually considered personal information. Well, it for sure is under CCPA. All right, so this brings us to our fun law school exam hypothetical, the Internet of Things. And what I found really interesting as I went back and was looking back through the history of privacy laws is there really is a strong correlation. I know I shouldn't use that word with this particular group of people, but a correlation between technology and the evolution of technology and privacy laws. Warren and Brandeis talk in their article about new photographic technologies that can record people in their homes. And there were articles in the 60s that were talking about basically wearables that collected biometric information and geolocation tracking and devices that could record your conversations without you even knowing it. And then in the 90s, when you start just seeing law after law being passed, you have the internet, you have faxes and text messaging and now bots, and just, the more technology evolves, the more complex it gets, and the more integrated it becomes with our everyday life and our personhood, our actual, physical being, the more laws we start seeing to be passed, right? So now that we are in this fourth industrial revolution where any device, pretty much anything in the world, physical world, can be collected, can be connected and start collecting data, and entirely new kinds of data that were just unimaginable, 10, 15, 20 years ago, how are these laws going to evolve? And how are they going to be applied now, in this new context? So this is the basis for our fun hypothetical. And we're going to think specifically about connected doorbells. And these exist today, right? You can buy them, video doorbells. This particular device comes from a patent application that recently published, owned by Amazon. I believe it's part of the Ring line of doorbells that Amazon purchased, but the patent is owned by Amazon. And essentially what this patent claims is a method to create a composite facial image from multiple partial facial images, so that way you can more accurately identify who it is at your door. I guess the problem is that if you have a camera that only looks this way and you're kind of standing here, you don't really know who it is. So they have this fancy, device that's inside of the lens to be able to capture multiple partial images, and then they put it all together to create a composite facial image. And then on top of that, the patent talks about potentially adding metadata. So for example, maybe they add data from the sex offender registry list, right? So to help you identify, is this person a sex offender? And are they then suspicious? And should I notify the police? Or they talk about maybe adding logo information, right? So they can pick up if you're a UPS delivery driver or something. It will maybe identify that in the image and tell the homeowner. Other kind of behavioral characteristics the patent talks about. So it's a video camera. They talk about collecting, for example, motion imagery to determine, are they crouching or are they loitering for unnecessarily long periods of time, right? Different behaviors that may indicate this is a suspicious person. And then the patent talks about, again, creating this facial image, overlaying this metadata, and sending it to the homeowner to be able to make an evaluation of, is this a suspicious person or an authorized person? And they can then share that information or that image also with their neighbors. So Ring now has a neighborhood watch app, which is basically a virtual version of your good old-fashioned neighborhood watch. And so people can help each other out and say, oh no, I know that guy, he's my cousin or whatever, right? He's fine. And you can also automatically send it to the police, in which case then the police would be able to make their own determination about whether they need to take action on this person. So that is our technology that we're going to talk about, this connected doorbell. And obviously the benefits are home security and safety and crime reduction. I mean, Ring boasts on their website that their doorbells have helped to reduce home burglary crimes by up to 50% in certain neighborhoods. So potentially very significant benefits to using this technology. But let's have a little bit of audience participation. So what kinds of personal information could this type of device potentially, theoretically, collect? Yes?
Did you see the article on this topic in the last week?
I have. We're going to get there. But let's stick with what kind of personal information could it collect? Sorry, what was it? Fingerprints, yes. Sure, you got to touch the doorbell, right? So scan your fingerprint. Yep, did you raise your hand?
Your picture and your location along with it?
Sure, yep. Your image, geolocation.
Gender potentially, and,
Sure.
and age.
Yep, yeah, absolutely.
Retina scan?
Yep, it does talk about that, scanning retina, iris, kind of other biometrics. Yep.
It can have a conversation, any audio with that?
Absolutely. Yep. Why can't it collect audio? It's doing video. Yep.
People you associate with.
Yep. Yep. Anything else come to mind? Yep.
Schedules,
Sure.
what time they're coming around, and things like that.
Right. Okay. So that may not be personal information, but I like where you're at, and we'll actually talk about that towards the end of the conversation. Yes?
Basically, the people in your life, if you're the one who owns the doorbell, anyone who's coming into your house and going, so you potentially might be indicative of your personal life. Like how you mentioned initially, if
Right.
you're somebody who doesn't want to disclose who you are.
Right. Right. So you're thinking more like the owner, the homeowner's information, for sure. Yeah. I mean, you've got to share your information with the company. But just think about sort of the device itself, right? If you come up to the door.
People who aren't actually intending to be at the door, but are walking by.
That's part of my hypothetical. We'll get there. Yeah. Yes, sir?
Wi-Fi monitoring for messaging.
For sure, yeah. Why couldn't it pick up that? Absolutely. Everybody's got their phone on them, right? Maybe it connects to it. Yeah, so these are all really great examples, and I think if we kind of kept thinking, you just go deeper and deeper into this and see that this technology is potentially very powerful. And I kind of like the idea of what if you connect it to like a connected door handle, right? So you have not only the doorbell, but the door handle. Now I've potentially got a palm print. I've potentially got, you know, my body temperature or my heart rate or, you know, blood alcohol levels. I mean, who knows, right, what could be picked up by this technology? And that's kind of the point. So all of what we just talked about would be considered personal information under the CCPA, without a doubt. The CCPA is very broad. It relates to any information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. And it, of course, all the usual suspects, social, driver's license, name, et cetera. It also covers online identifiers, so maybe your Twitter handle, et cetera. IP addresses, your purchasing or consuming histories or tendencies, internet or other electronic network activity information, including your browsing history, search history, and information regarding a consumer's interaction with a website, application, or advertisement. So all those fun little marketing, you know, OBA type of activities are now very clearly covered under CCPA. Geolocation data, audio, electronic, visual, thermal, olfactory, or similar information. So I guess if this device could somehow pick up your scent and record it, your scent would be covered. And then a whole host of biometric information, which we covered, like iris, retina, fingerprint, face, hand, palm, vein patterns, voice recordings, keystroke patterns or rhythms, gait patterns or rhythms, sleep, health, or exercise data. So just a huge, broad variety of information that is now covered by the CCPA. And a lot of that could be picked up by a connected doorbell. One thing that's important to note is that the definition of personal information under the CCPA does not include publicly available information, but information is not publicly available just because you're in public and I observe you doing it. Okay, so that is actually specifically not publicly available information under the Act. So the fact, you know, that you may be walking by in public on a public street, if I pick up that activity on this camera, that doesn't somehow make what you're doing publicly available, right? It also specifically says that repurposing government records or data in a way that is not compatible with the original purpose is not considered publicly available information, right? So that kind of makes me think about that sex offender registry list, right? Or the FBI's 10 most wanted. Are they repurposing that information in a way that's not the original intent? So is that actually publicly available information for them to use? I will also say there are three specifically biometric information protection acts in the United States. Illinois has the most punitive of all of them, but all of this information would also be considered biometric information under that act. And we'll talk about the Illinois Act a little bit more here. So let's apply the principles then to this technology. The first, notice and awareness. So obviously under CCPA and the Illinois Act, both of them require providing notice to consumers before you collect information about them. The Illinois Act actually requires you provide written notice before you collect information from them. So how is a doorbell going to provide written notice to a consumer before it collects this information about them? And it's not just the homeowner, it's anyone whose data is being captured. Very good question. I don't know if we have an answer to that. Second principle is choice and consent. As we know, the consumer has to say yes, has to consent to that. And the Illinois law actually requires that you obtain express written consent from the consumer to collect and use their data. So again, how are you going to get express written consent from the, the delivery guy who's just going up to the door to collect this information and to process it? Access and participation, our third principle. So here, right, this would require Ring to, the CCPA would require them to basically provide their file on you if you ask them. They have to provide that within 45 days. Given the amount of information that Ring is probably collecting and the fact that the homeowner can go on and add their own information, right? They can say, oh, I know you, your name is X, or identify their relationship to you. Ring probably knows exactly who you are specifically. I don't know that this information is being anonymized or, pseudonymized in any way. It would kind of make it a useless product if the whole point is to specifically identify people and be able to recall that information. So if they get a request under this act, they'll probably have to comply with it. It'll be interesting to see how that compliance requirement plays out once the law goes into effect. Integrity and security. I mean, how do you secure a doorbell? Right? All these laws require reasonable security and security that's appropriate to the nature of the device and the information being collected. There is no bright line. There's no clear standard about what would be considered reasonable security of a connected doorbell. I would say as well that California also in 2018 passed the first of its kind Internet of Things security law. So also, specifically requiring connected devices to be secured. So now, we have multiple laws on the books that specifically require a doorbell to be secured. But again, the practical, how do you do that? No good guidance on that right now. And the last principle, enforcement or redress. These statutes are for real. I mean, they have teeth. All of them can be enforced by regulators. Both the CCPA and the Illinois law can be enforced by private citizens. And they have statutory damages and potential for class action claims. So you think about the amount of data that's being collected, the number of consumers about whom data is being collected, and very potentially serious class action claims could be raised here if they're not complying with these laws.
Are you allowed to file a claim even if you don't actually have an injury?
So that's a very interesting question. I'm glad you asked me. He asked if you can file a claim if you don't have an injury, and that was actually my next point, was that just in the last 2 weeks out of Illinois, the Illinois Supreme Court answered that question under at least the Illinois statute, and they said that you do not need to prove any kind of financial or physical personal harm, that a violation of the act was sufficient to have standing because this addresses a human right. And so that pretty much answers that question, at least in Illinois, at least for the Illinois statute, right? I think there's still some ambiguity around that at the federal level, and other states may reach a different conclusion. But at least, in Illinois, which, as we know, is a very serious statute and has really hard compliance requirements and real teeth to it, real penalties, that's at least going to open the door to a lot of class action litigation in Illinois. Okay, so that's our law school exam. You all passed. Congratulations. Now, there are a couple of related concepts that I do want to touch on. They're not directly in the FIPS, but they are very important and emerging issues, and I think this is getting to some of the questions that we talked about earlier. The CCPA has this kind of fifth principle that they recognize. It's not overtly recognized in the FIPS right now, but maybe would be added to them in the future. And it's this principle of anti-discrimination, the idea that businesses should not be allowed to discriminate against consumers who exercise their privacy rights or based on their privacy choices. Now there are, the CCPA does provide for certain business models, right, where that would be appropriate, and you can offer different levels of goods or services based on the information you collect, right? So you want to personalize your services, et cetera. That still is okay. But if somebody says, I want you to delete all your data about me, you can't then, penalize them by providing them a completely different level of service or at a different price. But I think this kind of begs the question of what if the technology itself discriminates, right? And this is, I think we've seen a lot of press about this, in particular with this Ring product, and facial recognition technology. This is becoming an increasingly hot topic for lawmakers and just in the public. And the ACLU in particular, when this patent application published an article about it because they see it as connecting Ring with Recognition, which is Amazon Web Service AI facial recognition technology. And the ACLU had previously done a report on Recognition, which showed that basically it was not all that accurate at the end of the day. It incorrectly matched 28 members of Congress, identifying them as people who had been arrested for a crime. And unfortunately, the technology of these 28 people who had been falsely matched, about 38% of them were people of color. So this lines up with previous research that shows that facial recognition technology is less accurate for people with darker skin tones and for women. So we kind of have an issue here, right? And this gets to the idea of ethics, technology ethics and data ethics, and these potential unintended consequences of using this technology. Very good intentions. You want to secure your home, you want to secure your neighborhood, but very real potential for very serious unintended consequences here, especially when you think about, as the patent claims, if that goes directly to the police, right? And now you're not even doing anything. There's actually not been a crime committed at all, but someone randomly has flagged you as suspicious, whatever that means, and now you're going right to the police, right? I mean, it doesn't stretch the imagination to see the potential negative consequences of that. And I would say that, Amazon employees, shareholders of Amazon, civil rights organizations, in addition to the ACLU, and even Congress have now written to Amazon and Jeff Bezos personally and asked him to stop offering recognition to law enforcement. They want them to pull back on this technology until they can think through some of these issues and until some controls can be put into place. So the issue of unintended consequences from the collection of data, and especially the potential for discrimination, is very real, and I think something that we're going to continue to see a lot of attention to by the legislatures and by the public and different civil rights groups in the future. And the ugly truth here is a reference to, I don't know if you remember the revelation about a Facebook employee from a couple years ago who wrote this internal memo where he talked about basically their growth at all cost mentality, and even if someone dies because of a terrorist attack, right, that happened because of Facebook, connecting people, they still connect people. They believe in it so deeply that even if people get harmed, they're going to continue to do what they do. And so, it's kind of applying that mentality here. All right, so the last topic that I want to cover, which is again not directly related to the FIPS, but really important, is the question of who actually then owns the data. So in our hypothetical here, the device itself is manufactured by Ring, and they're obviously going to collect a bunch of information and have it on their servers, and they would also want to have information on the devices themselves, right? Are they performing well? What's the ambient weather? So they can continue to improve their product. In our little hypothetical, we had the postal delivery man, at the door. What about potential trade secret information that that Ring is now inadvertently collecting? To your point, right? They now have some employee data. Maybe they have trade or delivery route information, right? What are the USPS, the Postal Service's rights in this scenario? And then, of course, you have the individual who has all of this information about them being collected. What are their rights at this point in this information that Ring has, right? I mean, if Ring is going to go off and monetize it in all these ways, do they get a cut of that? Do they get some benefit of that? Who actually owns data? And I will tell you, the law doesn't answer that question really today. I think we try to apply other legal frameworks like intellectual property or other frameworks to it, but it's very, very unclear. And I'm not sure that IP, I'm actually a sort of IP attorney by trade mostly, that IP really actually is the right framework for this. I think even there's a question of, is data even intangible or is it tangible, right? I mean, there's some emerging kind of physics out there that shows that data actually has tangible qualities. And that changes the way that the law thinks about it then, right? And what doctrines may apply. The closest law that the closest case kind of that we have on this, I think, to date is a U.S. Supreme Court case that dealt with the phone book and copyright in the phone book. And so that case, one phone book was basically suing the manufacturer of another phone book and saying, you guys copied our phone book records, and you shouldn't be allowed to do that. And the court held that while the layout and kind of compilation and everything is potentially copyrightable, something that could be owned as proprietary, the data in it, right, the personal information, people's names, their phone numbers, their address, is just facts. It's data. You can't own that. So that's not copyrightable. And the Supreme Court, had this really kind of interesting analogy. They said that that information existed before the phone book did anything with it, and it would continue to exist even if the phone book did not exist. So the data was basically discovered, right? And they kind of draw this interesting analogy to this distinction between discovery and invention, for example, or discovery and creation, right? And we kind of are familiar with this from the patent context and the idea that laws of nature, things that naturally occur in nature, you can't patent that, you can't own it. You can't patent gravity and own it. You could discover it, but it's kind of there for everyone to use. It's just, it exists. So I think it's a really interesting analogy that they used in the copyright case, and it kind of, I don't know, for me it makes me think, so how does that apply then for personal information today, right? If data is just out there, right, I mean, and it just exists, then can anyone really own it? Should anyone own it? But I think these are all very important questions that will need to be answered, especially as our data economy continues to evolve and data monetization continues to become an extremely important data business model, right? I mean, the question of who owns data and then what rights do they have in that matter? It matters for securing financing and for being able to engage in all sorts of commercial transactions. So that's the end of my talk. I think I actually have some time left over to answer questions, if there are any.
Yeah, we have time for questions. Don't be shy.
Yeah, so I mentioned that article earlier. I think it was about ring and recognition. I haven't read it yet. It's in my little to-do
Okay.
lab. Did you read it or no?
Well, which article are you thinking about? There have been many lately.
It was basically talking about the idea by people installing either the Ring doorbells or I don't know if other companies have these doorbells that humans have, or people have effectively paid to install a surveillance network.
Right, well that's kind of the ACLU's concern, right, is that effectively what you have is a massive decentralized, privately owned surveillance system that the government has a backdoor into, right? So that's kind of underlying the ACLU's concerns with it. What I thought you were talking about was an article, I think just from the last couple of days, that San Francisco has now introduced legislation to actually ban the use of facial recognition technology by their city agencies. So wouldn't ban personal use, I believe, but at least use by the police and other city agencies.
Chuck?
Yeah, I have a question on your estimation of the litigation of these.
Yeah.
Because if this stuff is tied up for so long, is it really going to make a difference? You know,
right.
If it takes 10 years to establish a case.
Right. Well, yes, absolutely. So the question was about whether, I guess, litigation is really going to be an effective, enforcement mechanism. I think now that the door has been opened with the Illinois decision of the last couple weeks, right, that you do actually have standing to have a case just by a violation, a compliance violation. That is a very real threat, right? Because that was basically the argument before. If a company got sued, they said, well, they weren't actually harmed, right? There wasn't any harm here. They didn't lose any money. They weren't harmed. Nothing happened. And that's a requirement to bring a lawsuit, is that you have to be able to show harm. So this is actually a very important issue, because if they don't have standing, then you can't even proceed with a lawsuit. So at least in this Illinois statute, right, it's very clear. If you have just a procedural compliance violation, that's a harm. And it'll be interesting to see, how other courts react, and the legislatures and the regulators. But if that ends up being kind of the direction that this goes, then yeah, your companies are in for a world of pain, because you combine that with class action litigation and the potential for statutory damages, which can get up into the thousands per violation, right? So this is per violation. This is per person who has been harmed. You think about the number of data breaches that have happened lately, right? I mean, it's a similar issue in data breach legislation. This is why those damages can get to be in the hundreds of millions of dollars.
Is there a quick follow-up? Is there a chance that the Illinois statute could be voided by the U.S. Supreme Court?
That would have to depend on what happens with some of the pending federal laws, right? So there are increasingly calls to actually pass a federal privacy law because of our complex patchwork that we have now between federal and state and, overlapping rights. So if that law were to say that it preempts all other privacy laws in the country, then maybe, right? But I don't know if it would have that level of preemption, right? Mm-hmm. Yes, sir.
You may mention this in the beginning, but what is the differentiation between the data and the data derivatives or aggregated data? Does the law kind of differentiate between those?
Yeah, so he asked, are you talking about California?
Just in general.
Okay. The question was whether privacy laws generally differentiate between data and derivative data, right? I would say it depends. I'll give you the lawyer answer, right? It depends on the law, right? And some of them have distinctions between like anonymized and pseudonymized data, but they're inconsistent. Yeah.
We have questions for some of our legal representatives here. Oh my gosh.
Yes, sir.
You mentioned something about police having access to some of these devices. What's the precedent? I have no knowledge of what has happened thus far. So they have free access to the camera.
They don't have free access to the camera. The way the technology works, and like as the patent describes, is that the homeowner would be able to choose whether they send that to the police. It's basically a way to give the police a call, right, and say this is happening. I need you to come check it out.
Pushing a button, not uploading, not sending data there always, but sending data there.
Right. I would say that's true in the case of Ring. Now, recognition is different. Again, recognition is an AWS facial recognition AI technology, right? And they actually do have partnerships with local police departments for the police to be able to upload basically their photo databases or photographs from crime scenes or things like that, and to be able to use then recognition to help identify criminals or people of interest. I mean, they're using it in different ways, right? But they do have, police departments are actively using recognition, yeah.
Could you quickly elaborate on what you were saying on like, you were saying that being in public, collecting data isn't, I'm unclear about whether that's private or accessible. I thought that public conversations in a public space were not private.
Right, I mean, that's a good question. The question was basically the distinction between public and private, right, and observing behavior in a public space or recording it in a public space, and whether that's public or private. I mean, I think that's exactly the kind of ambiguity that this new law raises that needs to be answered.
But I know that like two important lawyers were overheard, and a reporter, reported on that in the news and didn't get sued because it was available. So some of the stuff that you're mentioning sounds like they're treading on that. Recording of something in public is bad, but people just listening in to a conversation is still okay.
Right, well, keep in mind that the Act really applies to businesses and corporate use of data and corporate collection and use, and there are some protections and carve-outs for like First Amendment purposes or First Amendment protections, right? But I think that the point here is that, if as a company, you can't just go and observe people on the street and consider that to not be personal information just because they're in public, right? Under this new law, my interpretation of it is that that is considered personal information still, because it relates to a person at the end of the day. Yes?
Is there any difference between collecting just information about a person versus tying it to a specific person? So just information about people in general or individual information?
The question is there a difference between collecting people about a person versus just people in general? What do you mean by people in general? Can you elaborate?
You're collecting a big amount of data about, a subset of 1,000 people or whatever, just for studies or something like that.
Right.
Nothing tying it to an individual person, or maybe they're just spread around, you just want that information. Do any of them, is there any distinguishment there?
Right, so I mean, it's the definition of personal information, remember, is anything that's even capable of being identified with a particular person. So I think you'd have to really, I'm not sure how you could collect all of that and not be able to tie it back to a particular person. But again, that's a great question, right? How is this going to apply to research activities? Because companies engage in research too, right? I mean, legitimate research. How is it going to, how are those kind of situations going to play out under this law? To be seen.
So does this mean, since there's like different state level acts, does this mean that if there's an app that has users worldwide, that they would treat each subset of users from different states' data differently? And how much confidence do they have to know about a user's like home state.
Yeah, no, that's it. I mean, this, when you start talking about especially multi-jurisdictional or international compliance, this gets very complex, right? Because now you have to think about multiple countries' privacy laws and regulations and how can you comply with all of them. And in some cases, yeah, the apps will basically have different versions for different people in different countries and different privacy policies, different disclosures, different data collection practices, right? Some countries even have data localization requirements, right? So maybe you have to actually keep the data in a server that's located in a country. You can't even have it cross borders, right? I mean, this gets extremely complicated very fast.
I guess I have one question about like regulation of it. So does, like, since there's so many laws and it depends on the jurisdiction, is it generally like for like the California one, does California have their own regulatory body that, like, I feel like for some of these you have to almost go into their data center and say, like, what data do you have and what have you been doing with it, or and audit them like physically.
Right, absolutely. So California does. It's the Attorney General, right, of California is primarily the one that would be bringing these actions. But each state has its own Attorney General, right? And then you have federal regulators as well. So, and then, you know, of course, other countries have their own enforcement and redress mechanisms.
So with that, I'd like to say that, you know, for the majority of us, we spend a lot of our time doing data science with our heads down, doing technical work. Hopefully this talk today that Helen gave provides a different perspective of when we're doing that data, how important it is to keep in mind privacy, the law, right? So with that, let's thank Helen again for a great talk.